I didn't hear that.
So when we left off on Wednesday, we were building into and talking about the different types of estates. Hopefully you remember this chart coming up on Wednesday. And we started to talk about what the differences were between the different kinds of interest, because relationship or interest is really all that an estate means. And we said that we were going to focus on the freehold estates. Somebody remind me, what does that word freehold mean?
Ownership.
Ownership. Listen, if that didn't immediately roll off your tongue, folks, this is where your note-taking skills have to kick in and you have to get better. When I ask a question like that and you don't know, that's okay. I'm not asking it for like entertainment purposes. I'm asking it to point out to you that's a word that needs to be instant for you. As soon as I say freehold, what needs to pop in your brain? We're talking about what?
Ownership.
Ownership, right? And so we started with that discussion of ownership. And what legal document did we say really becomes important when you're talking about transferring ownership, transferring that full deed. Right, there you go, that full bundle of legal rights. So here's the way I think of it, just kind of keeping the chart up here for a second. Let's do this and see if this helps. If we're looking at this chart, then everything that's freehold is going to transfer the full bundle of rights. Everything that's non-freehold is going to only transfer the partial bundle of rights. What right doesn't get transferred in a non-freehold or in a lease? What right?
Disposition.
Good. Exactly. The full bundle gets transferred anytime we're doing a freehold transfer. And so we started to talk about deeds and how they transfer. Now I'm going to skip ahead, kind of where we wrapped up. Right at the end of Wednesday, we talked about the most common, by far, transfer of the bundle of legal rights. And what did we say that was called? What was the name of that most common type of transfer that we have of the legal rights?
Simple absolute.
Fee simple absolute, or sometimes just referred to as fee simple. Sometimes they'll leave the word absolute off. Sometimes they'll put the word absolute in. They mean the same thing. But the key with fee simple absolute is that the grantor at that moment, and remember, grantor changes over time. Every time we have a change of ownership, we have a new grantor, a new grantee, correct?
Correct.
Okay. So the grantor on this particular deed, because every deed's going to have a new grantor and a new grantee, the grantor on this particular deed did not place any new restrictions on that bundle of legal rights. Everybody okay with that statement?
It's very important that when we're going through this section that you are keeping pace mentally. Because, we're starting at estates, which is the legal relationship to real property. You can have an ownership, which is freehold. You can have a non-ownership, which is non-freehold or leasehold. That freehold ownership side just keeps branching down and branching down. So that's why you got to make sure you really are following with this. If you're not, ask questions.
We're not doing new things. We're getting deeper and deeper into the same material. What we're doing now is going deeper into freehold estates. And what's the most common example of a freehold transfer? It's a fee simple absolute transfer.
So as we build onto that specific ownership estate, make sure you know the differences between them, because you'll probably get I don't know what, Travis, 6 questions on this. Maybe
it's a few for sure, but it's also about building a greater understanding for later in the class as well, is why it's so important. It's very foundational. So we talked about that fee simple absolute. Today, here's where we're launching off. We're going to the much less common ones. If fee simple absolute transfers are the most common transfers, what we're going to talk about now are the ones that are less common. What do you think is going to be different? Y'all help me out. I want you to think your way through that. If fee simple absolute means the grantor is transferring without new limitations, what do you think it's going to mean when we talk about these less than fee simple absolute ones?
They have
Limitations.
They get worse.
The grantor, and see, don't get lazy on that answer, because if you get lazy, you're going to get wrong. Remember, properties can have limitations and still be fee simple absolute transfers, because it's about that individual transfer. So when we talk about less than fee simple absolute, we're not talking about the property. We're talking about that one deed is less than fee simple absolute. That one deed is placing new limits on the property, and those new limits become appurtenant. What does that word mean?
It stays forever.
They stay with the land, right? They stay with the land. That once you put that deed restriction in place on one deed, it applies to every deed ever signed on that property from now until the end of time. Everybody okay with that?
Can we ask what? Cardi? Can we do a little pop quiz on that one question? Does fee simple absolute have any restrictions on the property?
No, not currently.
You just failed.
No new
restrictions. No new.
There you go. Fix it. Yes, fee simple absolute is almost always going to have restrictions. It just doesn't have any what?
No new ones.
Folks, you could travel.
Bosty posted in the chat that there was new ones. I want to make sure we understand that that's not.
Right. No new ones in fee simple absolute. Folks, almost every property has some type of restrictions. You're not going to find land that is completely unrestricted, meaning in thousands of years with hundreds of owners, no owner has ever placed any restrictions. That just doesn't exist. Fee simple absolute transfers means there are no additional ones being added, right? And Mark said, how do you get rid of restrictions? You don't. That's why they're appurtenant. They literally last forever. And I think you can say that and you can bobblehead it, but until you really internalize, this doesn't go away. These restrictions are attached to the property forever.
That too.
I mean, there are properties out there that have some of the silliest restrictions you've ever seen on them. You know, like I saw a deed restriction one time on a property that said that you could not have a female alone on the property at any time. That was a deed restriction I saw once.
Okay.
Can I just add something that has helped me to understand it too is we were once going to buy a property in Arizona. It was a gorgeous property and the people wanted it very specifically used for it was spiritual purposes, things like that. And she ended up passing away without ever selling the property. As important as it was to her, she did not remove any of those the criteria for it, and no one ended up buying it. And it was a shame because it was beautiful. So I guess it goes to whoever inherited it with that restriction.
With those restrictions, exactly. That's exactly right. Once the restriction, now does that mean that we're gonna have times where these restrictions come into conflict with more modern laws? Yes. And that's where the law would supersede these, but it doesn't mean the restrictions ever go away. It just means we ignore ones that come to violate subsequent laws. Let's be honest, folks. And see, this is where your brain's not kicked into gear yet. You're not, and it's expected at this point. Think. Humans are nasty critters, folks. And I don't mean in the sense of like they need a bath. I mean mean, nasty, vile critters. Let's just go back to say 1873. If you were selling land in North Carolina, what restrictions might you have placed on that land when you sold it if you were the prototypical North Carolinian in 1873 who owned land?
Some
Race.
really racist ones.
We wouldn't be able to buy it.
I mean, even the terminology that would have been used in the restrictions, or women can't own the property, or, there would be all kinds. And are those restrictions still attached to that property?
Yes.
Yes,
So
they are.
on that example, if you're selling property in Raleigh who had that restriction added back in 1873, but you're selling it today, 2022, January 14th, you're not adding any new restrictions, but there's still restrictions on the property. So that would be a fee simple absolute transfer.
And this is where your brain's going to get in your way. I haven't asked you if those restrictions are enforceable today, if they have any legal weight. That's a different question. Are the restrictions still there?
Yes.
Yes.
Yes,
Yes.
because they last how long?
Forever.
Forever. Enforceability is a whole other thing, folks. There are lots of laws on the books that simply don't get enforced. As an example, I'll use a modern example. Is it illegal to buy marijuana recreationally anywhere in the United States of America, according to United States federal criminal law?
It's still federally illegal, yes.
Yes, you are committing a felony, even if you walk into one of those stores in one of those states and buy that. It is not legal.
Right.
It is illegal. The United States Department of Justice has just chosen not to enforce those laws in states that have said they want it to be legal within the boundary of their state. Are you still violating a federal criminal statute?
Yes.
Yes, you absolutely are. The law didn't go away simply because you went to Michigan or the District of Columbia or Nevada, right?
That makes sense. It's still there.
Still there, but that's a different question of, is it enforced? And that's what we run into with these deed restrictions. The deed restrictions are forever, but if they ever run counter to the current law, then we simply stop enforcing them because they are counter to today's current public law.
That's a really good example. It's like the law is still recorded. It's just like the Zoom chat. Once you send it, you can't get it back. But it's still there. So we just might not enforce it.
Exactly. Lanesha, do you have a question?
I did. So when thinking about appurtenance, am I thinking of it the right way when I think appurtenance lasts forever because the current owner cannot make it any better than the previous?
You got it. You just explained it as well as I possibly could. Not only is that right, that's as well as you can possibly explain it. The current owner, the current grantor cannot improve the ownership interest. They can't take restrictions that previous owners put away. They can only make it worse. They can add more layers of restrictions. Does that make sense for everybody?
Yes.
So it never gets wider. It just keeps getting more narrow and narrow and narrow.
That's exactly right. That's exactly right. And so Mark said, so laws supersede restrictions that violate the law. Absolutely. As a matter of fact, isn't that why we pass laws? To come back and say these things that you've done in the past, we don't believe should any longer be legal, right? And so it doesn't wipe the restrictions themselves away. It just says we don't enforce those restrictions. They're no longer enforceable because times have changed. It's exactly right.
Okay. So let's stay on the right track. We're talking about the ownership, freehold, and now we're just getting more limited on that ownership.
That's right. So now we have a grantor who's taking the ownership interest that they received and saying, you know what? This is too good for the next person. What I got is too good to pass on to the next person. Whatever ownership I received, whatever ownership I have, I could pass it on to the next person exactly as I got it, but I am deciding for whatever reason to place more restrictions, more limitations on the next owner. Does that, give me a thumbs up if that makes sense for you now when we say it like that.
It does make sense. I hope it does to everybody else too. This would be like, Travis, if you were getting your property, you got it from Sandra and Vince, who are happily married still. They placed no new restrictions on the property when they deeded it to you and Drew.
Right.
So now you're selling it today, for instance, not really, but if you were selling it today, you would be like, oh, I didn't get any restrictions, but now I want to place some restrictions.
Right.
This is where we're going.
We have a decision to make as grantors. Are we going to pass it along exactly as we got it? Remember, I can't make it better, but I can pass it along exactly as I got it. And we're not talking about the physical condition of the property, folks. What we're talking about is the ownership itself, the what is related to our ownership. We can basically not change the ownership for the next owner, or we can make it more limited. That's the choice every grantor has. Now, keep in mind, the grantee has a choice. They don't have to accept that deed. And especially if I'm selling them the property, they don't have to pay me for it. Do you think there are grantees who are going to say, I will only pay you for the property if you give me a fee simple absolute transfer? What do y'all think? Do you think that
Absolutely.
might?
Yes.
Yes.
Absolutely.
Yes.
Matter of fact, if you were a buyer, what do you think one of the first things in your sales contract ought to say? I will pay you this amount of money for the property if you transfer it to me what?
Fee simple
Fee
absolute.
simple absolute.
Simple absolute. Don't you pile any more restrictions on top of me. Right?
Makes sense.
And so that the deeper those ideas get in, the better the rest of this stuff comes for you, I promise. So what we want to focus on now is the first of two things that the current grantor can limit for the next owner. The current grantor can either limit, and we'll back up for just a second, either the time that the next owner will own the property, limited time ownership. If you think about it, grantors don't do that. When I bought my house from Sandra and Vincent, did they say that Drew and Travis could only own this property for this period of time? Or did they just say Drew and Travis own the property and how long is up to them?
Yeah, they own the property. And how long is up to them?
How long is up to them? A grantor, folks, can get all up in your shit and say, you are only going to own this property for this limited period of time. Does that give me a thumbs up if that makes sense, that the grantor has the ability to do that? Okay.
Grantor, the one giving ownership, you and Andrew, y'all could say, hey, we're going to limit what you do.
Okay. So Alyssa said they would need to sell after that time. Worse than that, Alyssa. There's nothing to sell at that time. Their ownership is literally going to evaporate. Their ownership is literally going to evaporate after a certain period of time if the grantor places this restriction. The grantor is transferring ownership and saying, you own the property until, and when we reach that until moment, poof, it's like Cinderella. And
at midnight.
And the carriage turned back into a pumpkin. I hate to tell you, I mean, right? It's midnight and the party is over.
How would that be from a practical standpoint? I mean, why would somebody do that?
What? They're an asshole. I mean, that's the practical answer.
Assholes just do stuff and you can't even make a distinction. Why would they do that?
There are. Actually, hang on to that question mark, because as we
it's good. It's good.
So let me.
If somebody were to do that, would they be able to? The person who sold the house to them, the grantor, would they get ownership again if theirs ended?
Well, we're going to talk about that, Zeta. See, now Zeta's seeing, well, who gets ownership at that point? We're going to get there. We got to get through the transfer first, but it's a great question, and we're going to get there. Flo, what was your question?
Yeah, so during the time that I have ownership with this limitation of limited time, do I still have all of my bundle of rights?
You do. So hang on to that question too, Flo. We're about to get into it. You do. You have the full bundle of legal rights during that time.
Okay, Because would this also imply that I could technically sell before my own time limited?
There you go. You can sell as long as you sell before when?
My time of ownership is over.
Before your time of ownership is up, because you have the full bundle of rights.
Okay.
But that time limitation passes on to the next owner, right?
Well, it passes on to every future owner, doesn't it? Because how long do these restrictions last?
They last forever. And this is a good point, because I know Eddie had posted it. There's a couple of good things in the chat. Eddie had said, so the right of disposition does not transfer. Hang on to that, because I think it'll make sense.
It does transfer. Hang on
to it. It does.
Yes. Hang on to that
and
idea.
Then
but
also, I think it was Michelle, my chat's all over the place right now, had asked, these are appurtenances, correct?
Yes, these are appurtenances. Anytime you place a restriction on that deed, that restriction is what?
Appurtenant.
Forever.
So,
then one more thing, Travis.
Yes.
Michelle said, just so I understand, less than fee simple absolute is fee simple defeasible.
Fee simple defeasible is a type of transfer that is less than, but that is not what we're talking about right now. We are not talking about fee simple defeasible. That is a different restriction that can be placed on a deed. These are called life estates. The first transfer that we talk about that is less than fee simple, that is limited by time, is called the life estate. This is a grantor who has placed a time limitation on the grantee. And listen, you can, I promise this is a simple concept. If you think this is complex, it's because you're making it hard. Now, that doesn't mean it's going to be easy for you to let go of making it hard, but this is not a hard concept to understand. I want you to think of ownership, just think of this remote control as ownership. Stop thinking of it as land for a second and think of what we're transferring is the ownership of this remote control. Is everybody with me on that?
Yep.
Okay. We're transferring the ownership of this remote control. Can we all agree that the current owner has the right to transfer this remote control in any way they want to?
Yes.
Yes. And here's what I'm saying to you. The current owner is transferring ownership of the remote control to Flow for a limited period of time. Now, I've had people say, well, that's just a lease. No, it's not. It's better than a lease. Because in a lease, what one very important right does Flow not have at all and never will if she's leasing the property?
Right of
disposition. But in this case, even though she's limited by time when she gets this, if I'm handing it off to her, she's limited by time. She does have the right of what?
Disposition.
Of disposition.
Right.
She has the right to do what with this land as long as she is still within that time frame that the grantor set for her.
To sell it.
To market and sell it.
Sell it.
Sell it. And that makes it, no, a timeshare is not an example, Kim. Don't make, I promise you, I will never, ever not, if you think you're going to throw a word in there, be like, oh, it's that. No, Travis will always introduce the right words at the right time. I promise you. And if I haven't mentioned it, there's a reason I'm not mentioning it. And I realize you're scraping and clawing for something to hold on to. But here's the thing. It wouldn't make it any better if it was, because you don't know what a timeshare is either. You just heard that word before. Those buzzwords don't help you in this class. You got to retrain your whole brain, your whole way of thinking. This is called what, folks? What?
Life estate.
Like a
life estate.
We are transferring how much of that bundle of rights?
Okay.
All of it.
All of it.
All of it.
For a limited amount of time.
But for a limited amount of time. And
so I think it would be a good point, just remind yourself to put yourself in the shoes of who might be getting this ownership for a limited amount of time. Maybe if you put yourself at the center of it, it might help to kind of see what's going on, put yourself into perspective.
Well, yeah, we do have to look at it from the standpoint of both. Let's think about this for a second. If Flo now owns the remote for a limited period of time, can she use the remote in any way she sees fit? Does she have the right of control?
Yes.
Yes. Does she have the right to tell other people they can be on the property?
Yes.
Yes.
Yes. Does she have the right to be on the property herself?
Yes.
Yes.
Does she have the right to occupy the property for any reason she wants to? Can she live in it? Can she rent it out? Can she do all the things that an owner of real
Absolutely, yes.
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 But she is the what? And don't make it hard. She's the what?
The owner.
She's the owner.
The owner. It's hers. It's hers. She can do, don't make this harder. She can do everything and anything that any owner ever would or ever could do with that property. I want to make sure before I, open it up to questions or anything there, that we've got that in our head, that Flo is the owner of this property and therefore she can do everything that any owner can do. Are we all good with that?
Yes.
Jay,
and I'm sure Jay has a question, and I know there's probably going to be a lot of questions like, what happens? We'll get there. Just make sure you're getting the big concept right now.
Yep.
Sorry, Jay.
That's all right. What's up, Jay? You muted.
Let's see. You just asked you to unmute.
You're still muted. I still see the red thing. Try holding the space.
There we go.
Okay. How about now?
Yep. Gotcha.
Yes.
Okay. Here's my question. Let's say that someone puts a 10-year period of time on it. And let's just go back to the Flo example, because this is where I'm getting confused. Say Flo owns it and she has a 10-year
it's not gonna work. It's not gonna work that way. So we're not gonna say she has a 10-year. Delete that part. Let's say Flo owns it. Keep going.
When she sells it, how much of that is passed on to the new owner? Is it what's left over, or is it start
exactly? Where is the restriction?
10 years.
Where is it?
Well,
find it.
On time.
In the deed.
In the
deed.
In whose deed?
The owner.
Whose
Grantors.
deed? Give me a name. Whose deed?
Travis' deed to Flo.
Flo's deed. She isn't the restriction put on there when it was deeded to Flo?
Yes.
Yes.
He has to pass the restriction along exactly and precisely as it was given to her to the next owner. So whatever the restriction was that was placed on Flo, that restriction continues to exist. It doesn't change. It doesn't reset. There's no like, bing, reset the clock. No! Stop it. You're making it hard. If there's 36.3 seconds left, then how much time is the person that buys it from Flo going to own the property?
36.3.
36.3 seconds. That's it. Because whatever restriction was placed stays there. Here's the problem you're having. And Jay, I know exactly what problem you're having. You're sitting there going, who the hell would do that? It's none of your business. It's none of your damn nosy ass business. And that's what's
I'm the nosy ass too.
I have been in this class too many times. I know what your hang up is on this. I know, and that's why I'm yelling it at you, because your hang up, you're sitting there going, somebody be stupid. Look at it. Somebody be stupid. And look, there it is right there. That's the hang up. Folks, it's not for us to say.
We are not here to judge, interpret. We're just here to learn the law.
That's exactly it. I don't know why the grantor put this restriction on it when they gave it to Flo.
They just did.
And I certainly don't know why somebody would be willing to buy it from Flo with that restriction. But guess what? They did and they are, and we have to know that that's possible. Does that make sense for everybody?
Yes.
I think the way Travis comes across is that it might seem like, and he's really not being this way, but it might seem offensive to say, it's none of your damn business. But really, it's none of your damn business.
It's not.
Like,
So now I am going to go back to a question that was asked earlier. And I don't, it was either Mark or Jay, and I don't remember which one. You know, like, why would this happen in a practical, real world? Well, let me give you an example of where I've seen this sort of thing happen. Do people sometimes get divorced and remarried in real life?
Yes.
yes.
Okay. So now I want you to play Sandra, right? Okay. Now I want you to play this out. Let's say somebody late in life gets divorced. Okay.
Okay.
And then they get remarried. Now, let's say both new spouses have children from a previous marriage. Everybody following me so far?
Yeah.
Yes.
Now, one of these spouses had significant assets from their previous marriage. Do you think their children expect to inherit daddy's stuff when daddy dies? What do y'all think?
Yes.
Yes. But
From the first marriage.
From the first marriage. But here comes Anna Nicole Smith that's unmarried daddy. Are the children going to be all of a sudden very concerned that Anna Nicole may end up with all the daddy's stuff rather than them?
Yes.
Yes.
And is it very likely that daddy's going to die before Anna Nicole does?
Yep.
Oh, yeah.
Yes. Is that now? Here's the thing. If daddy leaves all his stuff to his new wife, Anna Nicole, is there any guarantee that she's going to actually leave it to his kids once she's dead? Or could she do anything she wants to with it?
She can do whatever she
Anything she
wants.
wants with it.
She could do whatever she wants to with it, unless daddy was smart. Could daddy leave it in his will to Anna Nicole until she dies, and then it goes back to his children from his first wife? Could daddy set it up like that?
Yes.
So it would be non-inheritable.
Yeah.
Yes.
See, and the thing is there, what he has accomplished is to take care of his new wife, but also make sure his eventual wishes get what?
Honored.
Get honored
Fulfilled.
long after he's gone.
Yes.
How many of you? And see, look at Deborah, lifetime rights. Deborah, I got to pick on you a little bit. What is the name of the thing?
Life
Life
estate.
Life estate.
Called a life estate. That's why it's called a life estate.
And see, now it's connecting. It is smart. This might be why somebody would do this. But then again, it's not our job to interpret why.
That's right.
But it does help.
It's our job to know it exists. Raquel, did you have a question?
I just wanted to say that I remember when Leslie said, whatever you do, don't fall behind and watch the videos before class. I understand why. Because
Oh God, yeah.
it all makes sense when you're watching the videos first, and then we're doing this, kind of feels like deja vu, but it
Right.
just
Oh, yeah.
all clicks.
Right. And that's the thing.
You hear it twice.
You might not have understood it when you watched the video the first time, but now it's like, oh, I totally get it. Right. It's like 2 for 1. It's like you're taking the class twice at one time.
You really have to do it that way.
Yeah.
So Travis, you said something that he would leave it to, after she dies, it goes back to the children in the will. How does that wording make it to the deed?
Because
Or does it?
It does, exactly does. Because how do you think we're going to transfer the title? How do you think we're going to transfer ownership to Anna Nicole after he's dead anyway?
Got it. Okay.
With a what?
Okay.
With a deed. And he's
I'm
simply saying
connecting it.
the deed that transfers ownership to her, I want it to specify she's only going to own it till she dies.
Which would be put in the deed. Okay.
That's
got it.
exactly
Even though
right.
it's the will that kicks it off.
That's right. But it makes it to the deed because it's a deed restriction.
Right. Okay.
Okay. Now, look at this question. It says Keenan owns a farm in Granville County and gives it to his niece, Kimberly. The will states that Kimberly will own the farm until her death, and then it will be transferred to the University of North Carolina as a gift. Okay. A, Kimberly will not be responsible for the upkeep, maintenance, and property taxes owed on the farm. Remember, this is the poll everywhere where you do it in your text messaging. Okay. B, Kimberly will not be allowed to will the property to her own children. C, Kimberly is considered to be a renter during this time. Or D, Keenan can change his mind after deeding the property to Kimberly. Look through those answers. Now, here's the thing. Just because you don't know an answer is right, eliminate ones that aren't possible, right? Eliminate one. That the process of elimination is huge, and it looks like
That's
a lot
the
of
number one test strategy. Eliminate.
Absolutely. Can we eliminate A pretty quickly? Kimberly will not be responsible for the upkeep, maintenance, and property taxes during her lifetime. Can we eliminate that?
Yes.
Yeah, because she absolutely will be responsible.
She's the owner.
Because she's the owner. She owns it. Flo, I'm sorry, you own it. You got to maintain it. You got to pay taxes on it, just like any other owner would. Okay.
So it's like, I'm all right with it.
C, Kimberly is considered to be a renter. Can we eliminate that one? Yes, we can. D, Keenan can change his mind after deeding the property to Kimberly. Folks, anytime you see something about changing mind after a deed's recorded, what can you do with that answer?
No.
Throw it away.
Here's what I always think about. The deed is done, right? The deed is done. Once it's a deed, that's it. There's no going back from that, right? And so, so let's look at the one that we're left with, which must be the correct answer. Kimberly will not be allowed to will the property to her own children. Even though the restriction doesn't say that, that's going to be the practical application, folks. How long is Kimberly going to own this thing? What does it say? She owns it until when?
Her death.
Oh, her death. She can't will something to somebody that she doesn't own. I can't will somebody, the Biltmore estate in Asheville because I don't what?
Own it.
Don't own it.
I don't own it. The minute she stops breathing, is she the owner of that property anymore?
No.
So she can't will to her children what she no longer owns after she did. Does that make sense for everybody?
Even if she did have a will, the moment she stops breathing, she's no longer the owner, so it does not apply.
And even if she wrote in her will, I will this property, I will this farm to my children. Is the law?
Oh, I'm sorry.
Is the law?
They're not the owner.
Travis, can you explain A again, like why would not she be responsible to upkeep? Like I just wanted to make sure I understand.
She is responsible. It says Kimberly will not be responsible. That's false. She is responsible for upkeep and taxes.
She's the owner.
The owner. Yeah. And so she cannot will things that she does not own. Yes, Louise. Hugh Hefner did this with the Playboy Mansion, as a matter of fact. So let me tell you what Hugh Hefner did with the Playboy. Some of you are familiar with Hugh Hefner or remember Hugh Hefner, who was the founder of Playboy, and the house he lived in Beverly Hills is a very famous piece of real estate. And people approached him for years and years and years and tried to purchase it. He didn't want to sell because he wanted to live there until he what?
Died.
He found a purchaser, folks, willing to pay him $100 million for the property, but let him keep a what in the property?
A life estate.
A life estate. So what he did was he deeded it to himself until he what?
Died.
Until he died, and then he specified it would go to the person who just paid him $100 million at his death. And that's exactly what happened. He lived there until the day he died. And listen, that man was not kidding around that bought that house. They wanted to have the funeral in the mansion. And the guy said, hell no, I've been waiting. He lived to be like 93. He's got to go out of here today. This is
same way.
Get the bodies out of here.
Right. I'd be like, get him out. I don't want his ghost here. No.
Exactly.
No.
Okay.
That's smart though. I'd let somebody do that for $100 million. Hell yeah.
Don't overly complicate these things. It's not our job to figure out what happens if, what if they're all dead? What if that's what the court system is for. Our job is just to know how the basic structure of how these things can be created. Does that make sense for everybody?
And two, it's not us who's going to be like advising our client what kind of ownership they should be taking or granting. We just need to know it.
What a great point. Who should be advising people about this sort of thing? That's a test question, by the way.
An attorney.
Attorney, right? An attorney. Okay. So when you look at these, there's some terminology that we need to associate with these people. The owner, the grantee, the person in our example, Flo, is the life tenant. That's the name that we give to that person. This is the person who owns the property while the life estate is going on. This is the person who has limited time ownership.
Right.
That's called the life tenant. Now, I know that word tenant can be confusing there. They're not a tenant, they're an owner, but it's what it's called. It's called a life tenant. Okay.
So we're getting into the vocabulary of life estates. This is where we're going right now.
That's exactly right. Now we're just taking that idea that we just talked about and defining the terms, the people, who these people are. That's exactly right, Alyssa. The person who received the property for the limited amount of time is called the life tenant. This is the one that the grantor signed the deed over to. Is everybody with me on that?
Check.
So as an example, my grandfather was a life tenant in a farm. You may have heard me mention this on the video. My grandfather's neighbors who owned the farm next door to my grandfather's farm died. They didn't have children. My grandfather took care of them in their old age. He was a very young man. This was in the 1930s. And when they died, they left him their farm until he what?
Until he died.
Until he died. That made my grandfather a life tenant on that farm. Could he farm the farm?
Yes.
Yes.
There was a brick house there. Could he rent the house out?
Yes.
Yes.
Absolutely.
Yes.
Could he have lived in the house if he had wanted to?
Yes.
Yes.
Sure. It's his farm for his entire lifetime. And they named what they said they wanted to happen with the farm after his death was that it went to the Children's Home of North Carolina. Well, that didn't happen until almost 70 years after they died. But when my grandfather died, guess what happened to his ownership of that farm?
Went to the children's home.
Poof, turned into a pumpkin, went to the children's.
Yep.
Cherie, what's up?
So this might be slightly off topic, but when we go back to like the Playboy Mansion example, we've all heard about the tunnels that go from that property to multiple other properties. So when those other properties were purchased, as far as their restrictions go, they were purchased knowing that there's a tunnel underneath and anyone that owns one of those properties can use it.
I don't know about that. That's way beyond our pay grade here. Like,
okay.
At least 25 steps beyond our pay grade.
Okay.
But
it would be under the restrictions, right? If
they were, yes, if those rights existed, they would be somewhere recorded as a deed restriction. Yes.
Okay.
Okay. And we especially know what happened in those tunnels.
Oh God, Travis, you were horrible. Jennifer said, so there's no purchase involved in life estates?
Well, it could be. I mean, a life estate can be a sale. It's a transfer of ownership.
100 million.
I mean, in Hugh Hefner's case, there certainly was a purchase price, but, and so there could be a sale. It could be done for free. They are often not sales because if you think about it, very few people are going to be willing to purchase something that they are only going to own for a limited period of time. That doesn't mean they're not allowed to. It can be a purchase, but it's just much more common that it's a gift or, somebody leaving it as a bequest and a will, that type of thing.
Yeah. Mm-hmm.
Are we all good on this life tenant definition? How do we all feel about that one? Good?
I do want to say, or I think I clearly understand it, but maybe breaking this down for myself and you confirming might help somebody else. So usually when we think about the word tenant, it's somebody occupying the space, right? But adding the word life to it is what makes it the ownership part for like.
Correct.
Okay.
Correct. And so this is not going to be like a specific period of time, like a lease would specify 2 years, 3 years. We don't know how long somebody's going to live. This is always going to be tied to someone's lifetime. And that's why it's called a life estate. Okay. Now, and we're going to get to Jay's question there. And Eddie, wrong. My grandfather could have sold that farm. Do not overly complicate this. Could my grandfather have sold that farm?
Yeah.
Yes.
Yes. But the restriction would have stayed in place, meaning whoever bought it from him would only own it until what happened?
Your grandpa died.
Until my grandfather died, because the restriction stays exactly the same.
Right.
Restriction doesn't say until the owner dies. It says until Robert Lane Franklin Robertson. My granddad had 4 names. I have no idea why. But until Robert Lane Franklin Robertson dies, Robert Lane Franklin Robertson owns this property. Well, he could sell it to somebody else, but what would their deed say? You own it until Robert Lane Franklin Robertson what?
Wait for him to die.
He dies. And so it really limits who might buy it, but you can absolutely sell it. Okay. Exactly, Flo. It could be sold, but because the death of that person is an unknown time, anybody buying it would be buying it for an unknown period of time. Could my grandfather have sold it and died 5 minutes later?
Yes.
Yes.
Yes. You know, heck, when he got in his 80s, we would have loved to find somebody who would buy that farm. Please buy it. Sure. We're going to lose it anyway.
Right.
But you're probably not going to find somebody willing to do that. Okay.
So these are very specific world examples. It could be somebody who wants to leave their property to their children until their children dies, and then it goes to their grandchildren.
Right.
Something like that.
Maybe they don't trust their kid. How many of you, let's be honest, how many of you think that there are people out there who their children are kind of not got their heads screwed on straight, but they have grandkids and they want to make sure their grandkids are looked after?
Yes.
Yes.
So could you not transfer ownership of your property to your children for their lifetime and then say at your child's death, ownership transfers to your grandchild? Could you not do that to ensure that the grandchild will eventually get ownership?
Yes. Totally could.
Totally can. You absolutely.
They're very specific.
Those are practical uses, right? Jay, again, you're making it harder than it needs to be, Jay. You're chasing your tail like a dog. Did you laugh at the dog when they chase the tail in the middle of the floor? Because that's what I'm doing with you right now. I'm laughing at you because you're making it hard on yourself and you don't need to. Can an owner make improvements to property?
Yes. They just
Can
can't.
a life estate owner make improvements to the property?
Yes.
Can an owner sell the timber rights?
Yes.
Yes.
You have every single right as a normal owner, except they just lose it at a certain time.
So the entire bundle of rights is applicable to that person.
Yes, exactly. And anything they do comes to an end when their life estate ends. So if they find somebody who wants to buy the timber rights, how long has that new owner bought timber rights?
Until that person dies.
Until that person dies.
Until the life estate ends.
Right.
Right?
Right.
Okay. Erica, can I explain how permanent relates to fee simple versus life estate time limited? Clearly, life estates are going to be time limited because the measuring life is going to what?
End.
Die. The whole point of a life estate is that the grantor wants it to do what at some point?
End.
To transfer end.
If a grantor transfers fee simple, are they going to ever have any control on it ending in the future?
No.
No.
No, it's up to the grantee.
Right.
Shay, what's up?
And so that if in the case of parent to grandchildren or to their grandparent to grandchildren, when the parent passes away, the grandchildren would have to have knowledge of that for it to be enforced.
No. Why would they have to have knowledge of it? This is
so they would be notified, is what I'm.
Of course they would, because whenever what triggers the end of a life estate, folks?
The death.
Death.
Also, the death certificate.
When someone dies, isn't there a document that says this person's now dead?
Yes.
And doesn't that trigger the disposition of all of their earthly property, both real and personal? Don't we have to now go through the probate process?
Yes.
Yes.
Yes. This is all going to be automatic, folks.
Yes.
The courts are going to track down the new owners and say, guess what? You own this property.
Right.
Nobody has to be aware. They probably are aware, but this is automatic.
Right. Do not mix the mortgage in here. Mortgage. No.
We're not worried about how we're paying for stuff. Okay.
No.
So let's talk about the measuring life. Let's talk about my boy Flavor Flav here. Yeah, boy. When you look at a life estate, every life estate needs to be timed. Except we don't time life estates with a calendar. They're called life estates for a reason. What is always going to be the measurement of a life estate?
Life.
Some person lifetime, or depending on how morbid you are, some person's what?
Death.
Right? Life estates end at death. Christina said, what's the term of the person that created the life estate? Grantor. They're the grantor. They signed the deed that created this life estate, right?
Sale.
So here's what you need to understand about the measuring life. It could be the same person as the life tenant. As a matter of fact, it often is the same person as the life tenant. If we give Flo ownership of the remote control until Flo dies, she is the life tenant because she is the what of the remote control?
Owner.
The owner. I'm going to say that again. Don't put them in a blender and hit were. She is the life tenant because she is the what of the remote control?
Owner.
Grantor. She is also the measuring life because I said her ownership would end when she what?
Dies.
When she dies. When Flo is serving both purposes, she is both things. She is the life tenant and she is the measuring life. But here's what you need to understand. The measuring life does not have to be the same person. Does the grantor have free reign to set this up any way they want to?
Yes.
For sure.
So can I, as the grantor, say, Flo, you own the remote until Praveen dies?
Yes.
Sure.
Yes. In that case, I'm going to say it again, and I want you to label them for me. Flo owns the remote until Praveen dies. What is Flo's title in this thing? Is she the life tenant or is she the measuring life?
She's the life tenant.
Is the life tenant?
The life tenant because she owns the remote. What is Praveen's role in this thing?
The measuring
life.
Is the measuring life. Does that make sense for everybody?
So that's a really good, important point. I think it's really good right now to go ahead and put your blinders on. We don't care about what's going to happen after somebody dies. Just focus on these two things.
Right. We haven't gotten to the after part yet. We're still talking about the during, right?
Yeah.
Now, here's the thing. Praveen gets no benefit from this situation. Being the measuring life is the crappiest job in the world. Because everybody's sitting around waiting for you to what?
For you to die.
For you to die.
Or not, in my case. I don't want
or not. I love it, Flo. Listen to what Flo said. Say it again, Flo.
I don't want Praveen to die. I want to keep living there.
There you go. If
You're like, Praveen, you gonna eat some kale?
Exactly. She's bringing him smoothies and superfood. You're gonna get some acai bowls every day.
Oh, good.
Living forever.
You're because she wants you to feel good. Meanwhile, somebody else, which we haven't talked about yet, somewhere is rooting for Praveen to do what? Die. Because somebody else is going to get ownership of this property once this is over. Does that make sense for everybody?
So they're bringing Praveen McDonald's and stuff like that.
Okay.
I'm horrible.
Rock climbing.
So if a person died, passed it to their grandchildren, and the grandchildren then had ownership of the property, would they be able to sell it to whoever?
You just answered your own question, Zeta. You said, I'm going to repeat your question. If they have ownership, can they sell it? If they have ownership, can they sell it? If they have ownership, can they sell it? What's the answer?
Yes.
Don't make it complex. They can sell it, but is there a restriction on that ownership?
Yes, as soon as Praveen dies.
And does that restriction stay?
Yes.
Yes, it does. Right? See, you all have to get out of your own way on that. This is ownership, except it is limited in one very specific way, which is what?
Dead. If someone's going to die.
Somebody's death. Somebody's death is going to trigger a change in ownership. That's it.
Right. There is nothing else that's going to measure this except somebody's death.
Somebody's death is going to trigger a change in ownership. Praveen, do you have a question?
This is unrelated, I guess, but in the case of your grandfather's, what was the stipulation that happened to the property after he died? You don't have to tell us if that's personal. But,
went to the Children's Home of North Carolina.
It went to the children, so they willed it to, or the deed said that it would go to.
That's right. His deed from 1938, when they died, said that he owned the farm until his death, and then it would go to the Children's Home of North Carolina.
I heard that earlier. I thought you guys were joking. I thought that was just
no, that's 100% serious. And here's the thing: that deed was from 1938. My grandfather lived until 2008. So 70 years after people were dead and in the ground, where their wishes followed to transfer ownership of that property to the Children's Home of North Carolina.
Did y'all know he did that?
Well, my grandfather didn't do it. He got it like that. I mean, he didn't know.
Okay.
They left it to him that way.
Okay.
Zeta.
So did you have another question, or is your hand just still up?
Oh, I don't have another question.
Okay.
Gotcha.
Travis,
So
I just had my grandmother send me a deed. We have a large piece of family land that we never touch. But it was deeded that it would go to all of my great grandfather's children after he died from 1911. That was really helpful.
Wow.
Yeah, there you go. Christina, we're not worried about what happens if the Children's Home of North Carolina no longer exists. That's what courts are for. We are not judges.
Right. There's going to be, this is so specific. Somebody could die, gender change, whatever. And I'm not making fun of it. I'm just saying, you got to just know that these blanket general statements, laws exist.
We have to learn enough law in this class. The last thing you want to be is a judge, you know? That's right. 4 years of law school. I mean, we can be here for a while. We're not doing that.
So we just need to know the basic, like general.
You know?
And so Brian had asked, who becomes the new measuring life person after the previous one dies? I told him you would get that.
There is no new measuring life. This is a one and done restriction. Whomever takes over ownership after the measuring life dies will take over ownership. What is our best way to transfer ownership with no additional restrictions?
Be simple.
Be simple, absolute.
Absolute. So
the life estate goes away.
So how does the Children's Home of North Carolina own that farm that my grandfather had as a life estate?
Fee simple absolute. No new restrictions.
They have no additional restrictions. And so this is a one-time restriction that once it's satisfied, it's been satisfied. It's not that the restriction went away, it's been satisfied.
Right. I said that wrong. So that life estate is no longer enforced. And Travis and I, Leslie, all of our instructors have been where you guys have been. We're thinking, well, what happens if this? What happens if this? Just don't do it to yourself.
Yeah, exactly.
Can I ask a question?
Sure.
I have a question. So someone can really screw someone else though, if the person doesn't want the property. So what happens if, like, say someone says, I will this to you upon your death or whatever, and someone's like, well, I don't want the property.
You don't have to accept that property.
You don't have to. But if there's stipulations, then that's going to make it hard to sell because
first of all, you can't at the same time say, I don't want it and I want to sell it. You can't sell it until you've done what with it?
No, receive it. He just said, then sell it. I said, but what if they just don't want it?
And what I'm pointing out is those are two different things, right?
Okay.
So if you don't want it, you just say, I don't want it. Don't accept the deed. Nobody's going to hold you down and force you to accept the deed. And if you don't, the courts will figure out what to do with it. If nothing else, it'll go to the state of North Carolina.
I need to take a second. Yes, I just need to take a second and make sure everybody is flowing with what we're talking about here, because I see Josh's question here in the chat, and I really want everybody to understand that as a life tenant, you are an owner. You can transfer ownership with more restrictions.
Right. So any owner can sign a deed and transfer ownership anytime they want to. And
add more.
You're not. If you're asking those kind of questions, you still haven't accepted the basic fact that a life tenant is a what?
Owner.
An owner. You can do anything any other owner can.
I own real estate. That's a life tenant.
There's just a lot of different similarities. Fee simple, absolute, fee simple, determinable, fee simple, defeasible. But you see the word life. I'm hoping that I really.
Here's the thing, Mary Ann.
Read the question.
They're supposed to be similar. They're all what?
Life estates.
They're all ownership.
Right.
They're all the same thing. Owning real estate. What's fee simple absolute?
Ownership.
No restrictions.
No new
restrictions.
No new restrictions.
New restrictions. That's exactly right. What's a life estate? The grantor added its ownership, but the grantor added what?
Time restriction.
Time restriction. That's it. They're supposed to be similar. They're not different. It's just very narrow little differences. A life estate, folks, is ownership. And it's the fact that you're trying to make them be so different that's causing you so much confusion.
Right.
A fee simple absolute owner and a life estate owner are the same thing. They can do all of the same things. The
only tenant is an owner. Life tenant is an owner.
Yes.
Measuring life is a separate, is the measuring life. Yeah.
That's it, right? It's an ownership interest. A fee simple absolute owner and a life tenant can do exactly the same things. Here's the only difference. The fee simple absolute owner is going to dictate when their ownership ends. The life estate, the life tenant owner has somebody else who dictated when it would end for them. The grantor dictated it to them. But while they own it, they're exactly the same.
Right. One is clearly better than the other for the grantee. However, it's still ownership.
So tell me, what things can the Children's Home of North Carolina, let's ask it this way. What things can the Children's Home of North Carolina do with that farm that my grandfather could not do with that farm?
They could sell it. Anything.
Well, your grandfather could sell it.
If your mouth opened, slap yourself. If you said anything, slap yourself. I'm going to ask the question again. What can the Children's Home of North Carolina do differently with that property that my grandfather could not do?
Not a damn thing.
Nothing.
Nothing.
Nothing. Now you can get into the willing part if you want to. Once that might be a slight difference, but they are exactly the same, folks. Can they sell it?
Yes.
Yep.
Yes.
Yes.
Did my grandfather sell it?
Yes.
Yes.
Yes. Can they rent it out?
Yep.
Yep.
Could my grandfather rent it out?
Yes.
Here's the only difference. My grandfather, the whole time he owned it, he knew that the clock was ticking. They don't have
Only
a clock.
difference.
They don't have a clock ticking.
Mhm.
That's it.
So
So
Eddie
can
asked
I
here in the
ask-
chat. Go ahead.
Sorry. On a deed, is it gonna say less than fee simple?
No, it's gonna say life estate.
Okay, because in the notes, there was a section that said less than fee simple, and I think that's what was tripping me up. So it's just gonna say life
It's just a
estate.
synonym, you know?
Yeah.
Okay.
But here's what you just asked me, Raquel. On the test, is it gonna say left foot or is it gonna say the foot other than the right foot?
Okay,
It's the same thing, right? You know, a life estate is less than fee simple.
Anything can also be achieved with making a restriction or appurtenance. I mean, anything.
Yeah.
Eddie had said, can an appurtenance be that the land could never be sold again as to giving it up to the university or the children's home?
Sure, but we don't go that deep in this
Right.
class. You know, again, some of y'all-
Anything can be
some of
accomplished.
y'all need to look into law school. You gotta know, stay in your lane. Our job, here's what our job is. If we look at a deed and we see the word life estate, we go, oh shit, that's our job.
Yep. Just got to know what it is.
You need to
It's
know
not our job to explain it.
what it is. It's not our job to get into the legal formalities of it. It's our job to say to somebody, hey, listen, you need to talk to an attorney before you go into this, because this is a weird form of ownership. Does that make sense?
Right.
yes.
Okay.
You
We're
see
not
a fee simple absolute transfer, you're like, oh, okay, it's fine. You still need an attorney, but
Right. Exactly. That's what our job is. We don't.
So just to go further with that, if we did have somebody that we were working with and we said, oh shit, it says life estate, we could say to them, you know, when somebody dies, it's going to go to somebody else, right? It's
That's
not
it.
gonna
And
be-
that, there you go. There's the full extent of your knowledge of a life estate. When somebody
Okay.
dies, it's going to go to somebody else. And so therefore we need to find out all the details and we need an attorney to explain all that to us.
Got it.
damn.
There you go.
we're basically going back to what 2.1, where we're reading the deeds and everything that's not included or included is what basically is going to follow on.
And here's what we're doing when we're looking at these deeds. We're looking for things that are out of the ordinary, not so that we can explain the out of the ordinary things. So we can just point to somebody and go, this is something we need to talk to an attorney about. This is out of the ordinary.
Okay.
We got to figure this out because something's going to happen when somebody dies. So just keep in mind, life estates is a time-limited restriction. And the two definitions that we've covered so far, life tenant is the one who is the owner who can do anything else that a regular owner could do. The measuring life, they are just somebody measuring the length of the life estate. It could be the same person as the life tenant. It could be somebody completely different.
Be somebody different. And that's up to the grantor who sets it up. Okay. Everybody all right with that? Kiana, you have a question?
Yes, you may have said this and I may have missed it taking notes, but say if like a grandfather, how we were talking about, they didn't want to leave it to their children, but they wanted to leave it to the grandchildren. If that grandparent passes away and the grandchildren aren't of age yet, at that point.
Again, I'm not an attorney and neither are you. I have to do that. All of that is so far beyond our pay grade. So far. Go to law school. You know, it really is about setting up boundaries. How many of you already feel like this is too hard? Like, honestly, you already feel like it's too hard. Don't make it harder.
It's confusing.
But it's only confusing because you take it too far. This is like somebody said, I sprained my knee. And the next question you have is, well, was it the medial collateral ligament or the anterior cruciate ligament? And did you do a drawer test? And can you go in there and surgically remove that arthroscopically? You would look at that person and go, are you a damn doctor? No. Well, then shut up. And I'm listening.
I like that analogy.
I'm not trying to be mean. I'm just trying to say all you need to know is the knee is sprained. That's it.
Yeah.
right? We don't
We need to know the surface.
We need to know the very surface level of this stuff, because that's all you're going to be asked about it. And quite honestly, that's all you're capable of giving in the real world, is a very surface sort of, here's what's going on. Let's talk to an attorney. Okay.
We need to wrap our whole brain around it. We just need to know the general.
Yeah, exactly. Exactly. Now, we finally need to talk about what happens after. And we've sort of brought this into the discussion. Are we all in agreement? Let me check where you are here. Are we all in agreement that we need to figure out what happens to the ownership interest in this property after the measuring life dies? Are we all in agreement on that? Does that make, when I say it that way, does that make sense for everybody? That, that the ownership of this property has to go somewhere when the measuring life dies. Is everybody okay with that statement?
Yes.
Okay. That is also up to the same person who got this ball rolling in the first place. Who wrote the deed that set all of this into motion?
The grantor.
The grantor. And the grantor makes the choice in that original deed. Do they want the property to revert, which simply means come right back to them? If they don't specify what happens with ownership of the property, and some of you had this question earlier, tune in. If the grantor doesn't specify, if they're not specific, guess where ownership is going to go?
Right back to them.
Right back to them. And don't you dare ask the question that just popped in your brain. I saw it flash across your eyes like it had a damn sign attached to it. I don't care if the grantor is dead. I don't care where they are, who they are, if they're dead, if they've been dead for 100. Nobody cares. That's what who's for.
Attorney.
Courts and judges. The only thing you need to know is that if the grantor is not specific, ownership is going to go where?
To the original grantor. Hey, could I throw something in there? Kind of a curveball. What is one example that we talked about very recently that would not be a reversionary interest?
Where the grantor was very specific.
Can you repeat that?
The children's home.
Oh,
The children's home.
My
The
grandfather.
grandfather's.
That would
I
be
guess,
one.
deed.
And also Hugh Hefner.
Hugh Hefner's. It didn't revert back to Hugh Hefner. It went to the person who paid him $100 million, right?
Right. So that would not be an example of this.
That would not those would be examples where the original grantor was very specific about what they wanted to happen. Reversionary simply means the original grantor was not specific. If I do, vague. We're going to go back to our original example here. Flo's going to be tired of this remote control. Flo owns the remote control until Praveen dies. Now, talk to me. Who's the life tenant?
Praveen.
Oh, Flo.
Flo.
I'm the measuring life.
The remote. Who is Praveen?
I'm the measuring life.
The measuring life.
The measuring life.
Right? Was the grantor, me, specific about what happens to the remote after Praveen dies? Or did I leave it open?
No,
you left it open.
You never said it.
If I left it open, it's going to revert. It's going to. Where's the remote coming after Praveen dies?
Back to
Travis.
Back to Travis, the grantor. Because the law will assume if I wasn't specific, that's exactly what I wanted to happen. Does that make sense for everybody?
But why would somebody do that? I don't know.
I don't know. Maybe they forgot who they wanted to list. I don't know, but the way the law is going to look at that is say, we don't know who to give it to other than give it right back to who?
The original grantor, Travis.
Original grantor, in this case, Travis. Does that make sense for everybody?
Yes.
Okay. And don't worry about if Travis is dead or if don't worry about that. That's what courts are for. They will figure that part out.
Right.
They will figure all that out.
It's natural to have all those questions, but we're not here to tackle those.
Well, and the thing is, we can't really answer them anyway because it would take a court to figure them out. That's why they're there. And Raquel's puppy is cute, super cute. It looks like a half Chihuahua, half Greyhound. It's a very long. I'm not sure what he is. It's cute though. Maybe a Jack Russell. Is it Jack Russell?
Chiweenie.
A Chiweenie. Oh, I thought it looked awfully long. I was like,
not too long.
Baby. Chewini. I like it.
So cute.
So
we love the fur babies.
What if the grantor is specific? If the grantor is specific, what we have is called a remainder interest. A remainder interest is one where the grantor specifies and says, I absolutely know where I want this to go. Does that make sense for everybody?
Yes.
And I love how Gabby said that. If you can look at the deed and you know the answer to who remains at the end, it's remainder. I love that.
Yeah.
If you can look at the deed and you know where this is going at the end, it's remainder. If you can't look at the deed and the deed doesn't tell you, it's what?
Reversionary.
Reversionary. Okay. And so when you look at life estates, we got to be able to just break them apart. Okay. So, Katie, the life estate terms would be on the one deed that it applied to. They don't remember, this doesn't transfer deed to deed to deed, even though the restrictions stay alive. You have to go back and research, and you would find one deed that had the life estate terminology on it. Okay. So Sam deeds a home to his sister Tina and specifies that Tina will only own the property until Tina's daughter Tiffany dies. At that point in time, the home will transfer to Sam's best friend Larry. So talk to me. Who's the grantor here?
Sam.
Sam. Okay. Who's the life tenant?
Tina.
Tina. Good. Who is the measuring life?
Tiffany.
Tiffany. Good.
Good job.
And is this a reversionary interest or a remainder interest?
Remainder.
Remainder, because it was specific and said it would go to
Larry.
Right?
Will we get a question that will say, what is like kind of like open-ended where it says, what is Larry in this situation?
Good.
I think so.
Maybe. I mean, it would be multiple choice. It's not going to be open-ended, but but yeah, it could.
Mm-hmm. And we've spent a lot more time than we usually do on this. So you guys better get this right.
Okay. So just again, adding to the vocabulary here. Remember, the life tenant and measuring life are two different jobs. Could those two jobs be done by the same person?
Yes.
Yes, they can.
If they are done by the same person, that is called a conventional life. So Jay owns this property until Jay dies.
Yes.
Jay is both the life tenant and the what?
Measuring
life.
Same person. That's a conventional life estate. Everybody okay with that?
Yep.
Is that with or with? Is that both with or without a will?
Either one. Either that doesn't have any impact on. Literally, conventional simply means Jay is both purposes, measuring life and life tenant. That makes it a conventional life estate. If there are two different people serving those roles, now you cannot just look at these questions and see, oh, there's two different names, because there might be four names in these questions. You have to specifically ask yourself, who is the life tenant and who is the measuring life? If those two people are different, Flo owns it until Cherie dies or Praveen dies. That was the example we were using earlier. Flo owns it till Praveen dies. In that case, is that the same person who's the measuring life and life tenant, or is that two different people serving those roles?
Different.
That's called a life estate per Autre V. When the measuring life and the life tenant are two different people, that's called a life estate per Autre V. And again, that's just vocabulary. That's the same idea we've been talking about. It's just adding a vocabulary to it. Here's what you can now do, though, using that vocabulary. You can actually completely break down these scenarios and tell me, and basically we're always going to get one label from column number 1 and one label from column number 2, because column number 1 is how is it going to work while it's going on. Column number 2 is what happens to the property's ownership when it's over, when the life estate's over. Is everybody okay?
I
with
want to
that?
say that one more time. Column number 1 determines what happens when it's going on. Number 2 determines what happens after.
Exactly. So look, and yes, Gabby, conventional life estates are not inheritable simply because the conventional life estate, you don't own it anymore after you die. Okay. So look at this one. Andrew will own the property until Andrew dies, and then it will go to Karen. This is what you're going to be asked to do on a test, folks. I want you to put them together. Talk to me. What do y'all think here? Andrew owns the property until Andrew dies. Do you think this is a conventional life estate, or is this a per Autre V? First of all, what do y'all think?
Conventional.
Yeah.
It's conventional.
Measuring line. Some of you are just looking at names. Oh, there's 2 names. It's per Autre V. Don't do that. Who's the measuring life?
Andrew.
The life tenant. Andrew. Conventional or per Autre V?
Conventional.
It is a conventional life estate because Andrew owns it till Andrew dies. Now look at column number 2. Remainder or reversionary?
Remainder.
Because Karen was named.
Remainder, because it's Karen. We know specifically it's Karen. Does that make sense? And here's how we know it's conventional. It's Andrew and Andrew, right?
Right.
So that is a conventional life estate with a remainder interest. Does that make sense for everybody?
Right.
Yes.
Yes.
That's a conventional life estate with a remainder interest. Look at this one. Seth will own property until Betsy dies, and then it will go to the University of North Carolina. So let's talk about this. Who's the measuring life?
Betsy.
Betsy. Measuring life to me looks like Betsy until Betsy dies.
Betsy does.
Right? And who is the life tenant?
Beth is.
Yeah. So is that conventional or is that per Autre V?
Autre V.
That's per Autre V because you got Seth and Betsy while it's going on, right?
Right.
People while it's going on are 2 different people. It's per Autre V. Is everybody with me on that?
Yes.
Yep.
Yes.
Who gets it in the end? Is it specific or not specific?
Specific. It's University of North
North Carolina, so it's a remainder.
That is a remainder. So this is a life estate per Autre V with a remainder.
So basically those columns, 1 represents life, 1 represents death.
That's it. Right. One is one. This is like during and after.
Okay. During and after.
Got it.
So look at this one. Mariah owns a piece of land until her death. Let's talk about during.
Conventional.
Conventional, because Mariah owns it until her death. Does everybody agree that that's conventional?
Yes.
Let's talk about after. Is it specific or not specific?
Reversionary.
Not specific.
My goodness, I think you're picking it up.
Not set out.
Very good job. Yes, I think it's really easy once you get it down to these 2 columns, even if you don't even have these columns in front of you. You just remember number 1. All right. What's happening during it? Is the life tenant and the measuring life the same person, or are they 2 different people? And then once you get to column 2, you just say, all right, what happens when that measuring life dies? Does it go back to the original grantor? Does it go to somebody else? That you'll have it down pat.
Yep.
And all we need to know is like get an attorney involved in this one, right?
That's right. For advice purposes. That's exactly right.
Yeah,
You
because
just
if it goes
need to be
back
able
to a dead person, you don't know
Right.
where it goes from there.
That's right. And
Not our
on
problem.
this, you just need to be able to identify these different types. That's it. So look at this one. I'm gonna let you do this one. I'm gonna let you think about this one for just a second. Simon has inherited a property that he will own until his oldest child dies. Okay. The during, is this
Pure Autre V.
conventional or per Autre V?
Autre V.
Autre V.
Per Autre V, I agree with that. And then the after, specific or not specific?
Not specific.
No.
Not specific, so it must be what?
Reversionary.
Engineering.
Talk to me. How do we feel about that?
Great.
I like it.
Good.
Good.
That's life estates, folks. And remember that what's the only difference between receiving a life estate ownership and receiving a fee simple absolute ownership?
It's just that it's time restricted.
Time restricted. Yeah.
Time restricted. The grantor restricted what?
Time.
Or how long do you have the property?
How long you own the property. That's it. It's the only difference. A life tenant can do everything that a fee simple absolute owner can do. And remember, no matter which one of these examples we're talking about here, whether it's remainder or reversionary, how's that next grantee going to own this thing?
Fee simple. Remember?
Fee simple. Right?
Because once that life estate is over, it is not honored.
Been satisfied. I mean, it's already been satisfied. People say it falls away. No, it doesn't. It's been satisfied, right?
So it's still there, but it's just satisfied.
Satisfied. We've moved past it.
You can't take it off of a deed.
Well, and why would you? Because at the end of the day, isn't that how these people got ownership anyway? Don't they need the life estate to stay there so they can say, this is how I got ownership? It came through this life estate to get to me.
Right. You don't want to break in that chain of title.
Right. That's exactly right.
Did anybody else just get really hangry? I got really hangry just now.
That's
really hangry.
Random quiz.
I just like noticed it. I was like, man, I am really hungry right now.
Very random quiz for you. All right. So let's take a quick break there. Okay. That's probably a good spot to take a quick break. Before we took our break, we worked our way through fee simple absolute. And then we worked our way through life estates. And life estates, remember we said, are the way that a grantor could limit time. Well,
Right.
remember, grantors can also limit what? Rather than limiting the time that the grantee is going to own the property, what can a grantor limit about the grantee's ownership? What the grantee
What it's used for.
Exactly. And that's where fee simple defeasible comes into play. Fee simple defeasible is a use-based restriction that the grantor has placed.
I know earlier somebody had actually asked, like, is limitations just defeasible? And Travis had answered, well, it's one type, which is the use. So remember, whenever we were just talking about life estates before break, that's another type of restriction. So I guess what I'm trying to say is life estates and fee simple defeasible are the two types of restrictions that you can place on property.
That's very well said. That's exactly right. Life estates are a time-based restriction. Fee simple defeasible is a use-based restriction. And it actually can be done in two different ways. And of course, they have two different names to them. Fee simple determinable is a type of fee simple defeasible. So I'm gonna go back to the chart again. Remember, fee simple defeasible, and now we're breaking that into two types of use restrictions. Just like you have conventional life estates and life estates per Autre V, two different kinds of life estates, you have two different types of use restrictions as well. The fee simple determinable, this is a really strict grantor. A grantor who signs a deed that's fee simple determinable has predetermined what this grantee can do with this property. And the grantee can only do what the deed specifies. The deed will be very specific and say the grantee can use the property for the purpose of, and whatever it says there, that's all. So if that deed says the property can be used as a park, can the property ever, for the rest of eternity, be used for anything other than a park?
No.
No, because that restriction becomes a pertinent, which means it lasts how long?
Forever.
So when these restrictions are placed, we have to be really careful as grantors to make sure that we're placing reasonable restrictions. Is this going to limit the marketability of the property pretty tremendously. Is this going to limit the number of people who might be willing to purchase this property if it has such a restriction on it?
Yes.
Yeah.
Yeah, for sure. When you look at the ability to restrict property in this way, this is often done when property is gifted for a specific. Here's the way I like to think of fee simple determinable with strings attached. This is somebody who is usually gifting property, but they're placing a lot of strings. Alyssa said, would this prevent development from ever being built on the land? It depends on what the restriction says. Here's what you need to understand, Alyssa. Whatever you could do on that property would be specified in that deed, period. And that's all you can do with the property. So if building a development's not listed, could a development be built? What do y'all think? If it's fee simple determinable and the deed doesn't say you can use it to develop, can it be developed?
No.
No, because literally the owners in the future of that property can only do what that deed specifies. That's it. The use has been predetermined by the grantor.
Yep.
And that restriction would carry through person after person after person. How do we feel about that one? Are we all good with that?
Yes.
Very strict restriction here. Now, the second category of use-based restriction is not nearly as strict. This is a grantor who simply lists the things that the property cannot be used for. It sounds worse, but it's actually way better.
Yeah.
Which would you rather have? A grantor who says you can use this property as a park, or a grantor that says you can use this property for anything except a hog farm? Which one would you rather have?
Anything but.
Anything but a hog farm.
Anything but a hog farm. This is the anything but a hog farm version. This
Right,
is
because
go for it.
sorry.
No, you're fine.
I was just gonna say that I'm hearing myself. I'm sorry. I was just gonna say because at least I could do the other 99 million things.
Well, that's it. You can do anything else with the property at all. It doesn't have to be listed on the deed. The things you can't do are the things listed on the deed. So this is basically a list of don't do this, don't do this, don't do this. Whereas that's fee simple subject to a condition. Fee simple determinable is the grantor has given you a list of the things that can be done with the property. And that's where the difference comes in. The grantor is in one case is telling you what can be done with the property. And in the other, the grantor is telling you what cannot be done with the property. So I've got a couple examples here. Fee simple determinable. Mary Ann grants ownership of a parcel of land to a charity so long as it is only used for a fellowship hall. Give me the full list of things that charity and every other owner from now to the end of the time can do with that property.
Fellowship hall.
Fellowship hall.
That's it. And that's forever. Permanent. Versus the fee simple subject to a condition. Bobby purchased a property from a developer who includes a deed provision stating the land may never be used as a hog farm. What can Bobby do with the property?
Anything that make it a hog farm.
Thing except make it a hog farm. And that restriction is going to stay for not just Bobby, but every owner in the future. How do we all feel about those?
Good.
These are pretty simple.
These are pretty straightforward. Yeah. So look at this question. It says Donald grants ownership of a parcel of land to Mary, and the deed states that the property may not be used for the purpose of development of a mobile home park. This is an example of, do we think this is fee simple absolute, fee simple determinable, fee simple subject to a condition, or a life estate per Autre v?
Subject to a condition.
Yeah, second there. I like the way your brains are headed. Subject to a condition. subject to a condition. If it was determinable, would we be would Donald be telling Mary what she couldn't do, or would Donald be telling Mary these are the things you can do with the property?
Determinable would be can do.
Determinable.
I like to think about it as determinable as like this is determined.
Right.
But
it's super strict. Exactly.
The subject to a condition, I like to think, all right, you can have it, but
under one condition. You know, it's like it even sounds like nicer, right? You own the property as long as you follow these conditions. But with determinable, it's like you own the property, but we have determined you can only use it for this. That's it.
Right.
Okay. And so those are the use-based restrictions that a grantor can place on the property. Of course, we know fee simple absolute is when the grantor doesn't place any restrictions additionally on the ownership. And a life estate is when the grantor places a time-based restriction rather than a use-based restriction. We already mentioned this earlier, but you do have a slide that mentions it. Pretty much all ownership is inheritable, can be left as an inheritance, except one. And we remember that word fee versus non-fee. Fee means inheritable, non-fee means not inheritable. The ownership types that can be left as an inheritance is a big long list because it's pretty much all of them. The ownership types that cannot be inherited is one thing. What's the one type of ownership that cannot be left as an inheritance?
Conventional life estate.
Conventional life estate. Conventional life estate. That's the only one. And folks, if you do this now, how many of you feel like now, oops, let me do that. Mark this out for a second. How many of you feel like now you could actually make some sense out of that?
Oh, heck yeah.
That now you actually understand some things. Does this chart make a little bit better sense now than it did when the first time we put it up?
Yes.
Of course, because yes, it does. And it's okay if you look at it and it takes you a second, but that's the point. You got to like look at the words, break them down, see what they mean. And, you know, I mean, obviously, if you can get it right away, I think it's great. But if you just think about what they are, it'll make sense. And I know John had private messaged me earlier when we were going through the life estates. He said, this is actually what I'm going through with my mom right now. And I was like, it's empowering to know this kind of stuff so you can know what's going on these deeds.
For sure. Absolutely. Pearl, so with fee simple subject to a condition, you can add another condition if you wanted as the owner, but with fee simple determinable, no matter who is the owner, is predetermined what the property use is, and that can never be changed. I think you're making it again harder than it is, Pearl. In neither case can the restrictions be changed. You can always add more restrictions. But in the case of determined, you've probably already been limited down to only one thing. So it's hard to get more limited from there. Whereas with subject to a condition, you know, you can own this property as long as you don't build a hog farm here. Well, somebody else could come back and say, well, you can own this property as long as you don't put a rock quarry on the property. But here's the effect. New owners can't do a hog farm or a rock quarry because they have to take all the restrictions and add them together. Does that help? Okay, good. Good. I try to look at you when I'm asking a question because I know a lot of times it's easier to give me a thumbs up or thumbs down than it is to unmute yourself. So try to. Those are all of the ownership interests.
Could you go over the fee simple defeasible again?
Fee simple defeasible simply means a grantor who has limited use when they transfer ownership. So we just talked about the two different types of use limitations. Fee simple determinable and fee simple subject to a condition are both. So like, think of it this way, you know, because I know sometimes silly but stupid analogies help. These are shoes, left and right. Okay. Fee simple defeasible are shoes. Fee simple determinable is the left shoe. Fee simple subject to a condition is the right shoe. In other words, fee simple subject to a condition, fee simple determinable are both fee simple defeasible. It's just two different types of fee simple. Does that help?
Yes, 100%. Yeah, yeah. And then I was going to say something about what the left and right one. In my head, I'm thinking about feasible, determinable, and subject to a condition as, like, for example, like operant conditioning, like in psychology. Like, for example, simple determinable is the positive side, like you're adding something, you're adding a restriction, and subject to a condition, you're one less thing, so it's negative. I don't know.
Yeah, same idea. Exactly same idea. Don't do too much psychology. I get scary. I don't want to know what happens up here. It's just a terrifying place. So that covers all the ownership interest. That's not all the estates, though. Remind me again, what does the word estate mean? It doesn't mean ownership. It
Relationship.
means
Relationship.
So if we've talked about ownership relationships or freehold relationships, what relationships does that leave that we have not yet talked about?
Non-freehold.
Non-freehold, which are the same thing. What's the more simplified terminology for non-freehold?
Leasehold.
Leases, exactly. Leasehold relationships. These are the flip side relationships. These are not people who own the real estate we're talking about. Their relationship to the real estate is not that they own it. Of course, there is an owner. We're not saying that this property doesn't have a freehold interest. Somebody has to own it. Let me be clear. I mean, those of you that rent your property, you have a non-freehold interest in that property, but isn't there somebody that you pay rent to that has a freehold interest in that property?
Yes.
Yes.
Right?
Yes, there is.
Okay. So
we get all those rights, the bundle of rights, except that disposition.
That's exactly right. The landlord holds on to that right of disposition. So what we're talking about with leases or non-freehold estates are temporary transfers of less than the full bundle of rights. I'll try to write that here. We're talking about temporary transfers. So they're not permanent. And not the full bundle. What right is left along the wayside is not going to be transferred here?
Disposition.
Right. So these are temporary transfers of less than the full bundle. Good. Very good. And we call them, in legal fancy terminology, non-freehold estates. And there are, just like everything else we've talked about thus far, there are multiple types of non-freehold. Just like there were multiple types of ownership estates, there are multiple types of leases. And we're going to talk about the 4 different types of leases. So again, just kind of keeping this straight, these are just the different types of leases. We're just breaking out the 4 different types of leases that exist. And I promise you, we're going to come back and talk about leases much more extensively later in the class when we do property management. For right now, all we want to do is introduce the idea of leasing an interest in property, and particularly how we identify the different types of leases from each other. And we're not talking about like residential leases, commercial leases. That is not the identification we really care about. What we care about is how the lease ends. Can we all agree that leases have to end? That because they are a temporary transfer, they have to come to an end. Does that make sense for everybody?
Yes.
And so the biggest differentiating factor in leases is the way they end. How does the tenant leave the property? What triggers the end of this lease? And if you notice, there's 4 bullet points on here. There's 1, 2, 3, 4 ways that a lease can end. None of these are ever going to be combined. These are ors here. In other words, some leases require the landlord or tenant to give notice. How many of you, raise your hand, have heard of a lease where the tenant had to give a certain amount of notice if they wanted to vacate the property, or the landlord had to give the tenant notice if they wanted to lease in? How many of you have heard of that type of lease? Okay. So we're going to talk about that and give a name to that type of lease. Look at number 2, though. There are certain leases that don't require notice, that when you look at the lease, it's not going to specify anything at all about the tenant having to give notice to the landlord or the land. Because here's what you need to understand. If the lease doesn't specify notice, guess what doesn't have to be given? Notice. And so when leases don't specify that either the landlord or tenant have to give notice, that's a different type of lease than what we had in number 1. Look at number 3. It says some leases have no beginning and no end. In other words, they are completely non-specific. What's the most important thing about a lease other than the rent that you actually pay, the money that's paid? When somebody talks about their lease, what's the first way they describe it? I have a 1-year lease. I have a 3-month lease. I have a 10-year lease. What's the most important thing about a lease? Time. There are some leases that don't specify an amount of time. They're rare, but they exist. And we got to put a name to those. Right. And then number 4, there are some leases that involve tenants who just honestly shouldn't be there anymore. They were supposed to leave. They had another one of the first 3 types, but that time has come and gone. They were supposed to leave and they won't do what? The tenant is refusing to do what?
Leave.
Now,
Leave.
this is what Travis and Leslie were joking about on Wednesday that I had with my previous landlord.
Exactly. That there are certain situations where the tenant is supposed to have vacated the property and they don't, and that becomes a different type of lease altogether, a different type.
Watch Judge Judy. She deals with this all the time.
That's exactly right. That's it. That's it. So let's put some names with these. This is number 1. This is the one that requires notice. A lease that specifies that either the tenant needs to give notice to the landlord or the landlord needs to give notice to the tenant. A lease that says if they don't give notice, it's just going to keep going. It's going to renew itself. It's going to become month to month. It's going to become year to year. It's going to keep going. In other words, it doesn't end until one or both give what?
Notice.
So when you're trying to differentiate this on a test, what is the key thing you're looking for?
Notice.
If it gives notice.
If it gives notice. If it says that this lease requires notice, then it is a periodic tenancy. Periodic literally means notice.
Yep.
Now, periodic could be week to week, it can be day to day, it can be month to month, it can be year to year. The time frame does not matter. What matters is the notice. Are we all good with that statement so far?
Yeah, and I think something important to remember is even though if this has a termination date, if no notice is given, it's still going to renew.
That's exactly right. I love that you said that, actually. So like you just moved to a new place. You sign a lease?
Yes.
For what period of time is that lease guaranteed?
For 1 year.
It's a 1-year lease. What it really is, though, I'm almost be willing to bet you if you pulled it out and looked at it, it says it's 1 year, but you have to give your new landlord a certain amount of notice. Otherwise, that lease is going to be what?
Continued.
Renewed. Continued.
It's going to be continued. It's going to renew itself. And so the fact that that lease specifies you having to give notice or the landlord having to give you notice means it's a periodic tenancy.
Yes. It's kind of strange because my previous one, I didn't have to give any notice. It was actually just a verbal lease. And I was there for like 2 years, but now it's all different.
We're going to talk about what you had before. We're getting there.
Gotcha.
Right? We're getting there. So, and Jay said the notice can be initiated by either party, correct? Yes. It can be. It can be. Right? So notice equals periodic tenancy. This is the one you're going to have to be careful of because it's called an estate or for years, a lease for years. But the truth is, folks, It doesn't have to be for years. It can be for minutes. It can be for days. It can be for weeks. It can be for months. It can be for years. The time period is not what matters. What clearly signified a periodic lease?
The notice.
Notice. What do you think is going to be the big difference in recognizing on the test the difference between an estate for years and a periodic tenancy?
No,
The notice.
If the lease does not specify notice, but it does, it does specify a definite period of time. The time is clear. So on this one, time is yes. Notice is yes. On this one, time is yes. It specifies an amount of time. Notice is what?
No.
No.
No. Everybody with me on that? So somebody said it's like an Airbnb. Bingo. If you go and you rent an Airbnb for 2 days, do you have to give notice to the landlord that you intend to move out, or is it understood your ass is going to be out after 2 days?
Yes.
Understood.
It's understood. Does the landlord have to give you notice?
Nope.
No.
Does that thing automatically renew itself, or are you in a place you're not supposed to be if you don't leave by that specific time?
You got to leave or you are in violation.
Yeah.
That is an estate for years, even though it was only for 2 days.
So this would be like a vacation rental?
Could be vacation rentals. It can be any rental which specifies a period of time. Staying in a hotel. Staying in a hotel is an estate for years. It specifies a period of time, but they don't have to give you what?
Notice.
Notice. They don't have to come knock on the door and say, Mr. Thomas, checkout time is at 12 noon. And if you don't,
I'm sorry.
And if you're not going to check out by 12 noon, you have to give us notice of that. Otherwise, we're going to renew and you got to stay for another night. They don't do that.
Right. That's not going to happen.
It's not happening. No notice required. It's an estate for years. Does that make sense?
I do like this picture you have on there though, because it's also like, like a firm or a pizza shop or something like that.
It's very commonly used in commercial real estate. Most residential leases are periodic in nature. Most commercial leases are estates for years.
For years. Okay.
More tenant rights.
Now,
residential.
Let's talk about the third one. This is a lease that does not specify time and does not require notice. It is a lease that has no specifics at all. When you ask the person, how long have you leased the property? They're like, I don't know. When you ask the landlord, how long is the tenant going to say? I don't know. That's called an estate at will. They have both just decided it's okay for the tenant to be there. Now, whatever arrangement they've come to, doesn't matter. Maybe rent's being paid, maybe rent's not being paid. But here's the key thing. Neither party can hold the other party responsible because they never promised time to each other. Can the landlord kick the tenant out on a moment's notice or leave on a moment's notice if they have an estate at will?
Yes.
Yeah. Can the tenant just leave and never even tell the landlord they're moving out if they have an estate at will?
Yes.
Okay. Shay, estate or tenancy will be used interchangeably.
Right. Good question.
Right.
So they don't need to notice at all. They could just come up and say you got to move out.
Correct. An estate at will makes no promises for time. Now, Christina said it's an unwanted guest. I would not say that, Christina. This is a guest that you have given permission to. So like Seth, you were in a place where you had no formal agreement with the landlord, correct?
Correct. No formal agreement.
You didn't, the landlord had not promised you could stay there for any period of time, and you had not promised the landlord you would stay there any period of time, correct?
Right. Correct.
Were you
kind of like squatting?
Well, but no.
Rent. I was paying rent.
He was paying rent.
It was more like just a verbal negotiated thing with a buddy.
It don't make it harder than it is. It is literally, I'm
You
fine.
can
with
stay
it.
here.
You can stay here.
Okay.
And they can work out rent if they want to, but they've not made any promises to each other. Tomorrow is not promised. Could the landlord tomorrow say, get out?
Yes.
With your parents.
And the tenant can get out. There's no agreement here. There's no holding each other responsible. That is an estate at will. This is very uncommon in lease situations because it's very wishy-washy. How many people would honestly feel comfortable living in a place where they're not guaranteed tomorrow?
No.
Probably not, right?
Right.
So in the
Now,
absence
yeah, go ahead.
of the agreement, you would just have this, correct? If there was no other type of lease agreement, it would just become an estate at will?
Well, Christina, that really varies from state to state.
Okay.
Every state has different laws about kind of what the default one of these is. And I don't want to get into that now because that's sort of beyond where we are at this point. You know, we're going to talk specifically about North Carolina landlord tenant law later on, but in some states that would be true, in some states not. But you just need to know that if you have this relationship where there has been no commitment whatsoever, that's an estate at will.
So there's no beginning, no end, no commitment, kind of like trying to get your son off your payroll. Your son comes home and stays and he can leave anytime or you can kick him out anytime.
That's it. That's exactly right. That's exactly right. You know, or your friend comes and crashes at your house, you know, for the weekend and you're fine with that. But here's the thing. On Monday morning, if you wake up, you'll be like, all right, you got to get your ass out of here now. I can't stand it.
You eating my food.
They can't take you to court and say, I had a lease because they never what?
Signed one.
They never agreed. You never promised them any period of time. They never promised you they would stay for any period of time. It's literally it is permission to occupy a property, but with no future commitment. Are we all good on that?
Right. So I had an estate at will, but I was respectful and I gave some notice, but I didn't have to.
You didn't have to. There was no commitment there. Okay.
This seems like the lease version of life estate, pure Autre V.
I'm not sure what connection you just made.
Like, okay, so like for the pure Autre V, like the being an owner based on somebody else's, you know, whether they die or not. So I could be kicked out at any moment in time when they die.
I got you. You just being out of control about the timing, but at least you know it's going to happen specifically. You have a promised period of time, though. Here, this is literally no promises. I mean, somebody could 5 minutes. I mean, they could be standing in front of you, and like you could. I mean, like here, an estate at will. Let's say your landlord comes over, and y'all are having a nice chat on the front porch, and you're like, well, I got to go. I'm going to be watching the basketball game this afternoon. Oh, you're a Duke fan or you're a Carolina fan? Well, I went to school at Carolina. Get the hell out of my house. Because an estate at will, there's literally no commitment. I mean, it could be for any reason, no reason. I mean, there's no commitment made at all between these two parties. Okay? Very rare to have an estate at will for obvious reasons. I mean, why do we have leases? Hold people what? Accountable for promises. This is a lease that there's no promises made. Zero promises. None. Everybody okay with that?
Yes.
Okay. Now, the estate at sufferance. And this is where you have to not be so regimented in your brain. Something could start as a periodic tenancy and end up as an estate at sufferance. A tenant at sufferance or an estate at sufferance is simply a tenant who at one point had one of the other three. They had a periodic tenancy, they had a estate for years, they had an estate at will, they had one of those three. They have exceeded their welcome. They have overstayed. They've been asked to leave, whether that was with notice in the periodic tenancy, or they've simply gone past the lease expiration in an estate for years, or they had an estate for will and the landlords told them to leave. This is a tenant who has no legal right to stay, but they're refusing to do what?
To leave.
To leave.
And you know, I do see Alyssa's comment here in the chat now, possibly a squatter. And I used to think about it that way too. And I could never understand why Travis would be like, well, it's actually not a squatter. But now it does make sense because this is a person who had the legal right to be here, but then it went away.
A squatter is somebody who's trespassing. A squatter
never had the right.
Never had the right. Here's the thing, Christina, you can call police all you want to. The police can't do anything about this situation. And that's why this is not a squatter. The police cannot make this person leave because the only way to make someone leave who was a tenant, who had the legal right to be there, is to go through the legal process known as what, folks?
Eviction. Oh, got it. Eviction.
So one way of looking at it is a tenant at sufferance is one who is going through what legal process?
Eviction.
The eviction process. They are at sufferance while the landlord is trying to get them out. They are there. Who's suffering in this? Where does the name come from?
The landlord.
The landlord is suffering because
get out of my property.
Because you have a tenant who won't leave, even though they no longer have the legal right to be there. But you can't just call the police. The police cannot. Now, can the police remove a trespasser?
Yes.
Yes. Can the police remove a squatter?
Yes.
Yes. But the police cannot remove a tenant at sufferance. Does everybody see the difference there? Only
big difference.
Only the courts can remove a tenant at sufferance.
Mm-hmm. Because they had a legal right before. There's no telling what has gone on. So we do need a court.
Yeah, most likely this tenant is not paying rent. It doesn't matter because if they were still paying rent, the landlord's probably not telling them to get out. Whether they're paying or not, they're still a tenant at sufferance because they don't have the legal right to be there. And one of the things that they'll tell you as a practical matter is if you want them at sufferance and you want them out, don't take rent because courts through that is you renegotiating a new lease.
Mm-hmm.
Okay, Christina, I'm just telling you, it's different. A trespasser is somebody who never had the legal right to be there in the first place.
Right. This is somebody who began with a legal lease. They had the legal right to step foot in the property, and now it has trailed on to you no longer have the right to be here, but you're still here. Get out.
Somebody who rents an Airbnb for a week and they stay 2 weeks, they are a tenant at what?
Sufferance.
It's sufferance. Somebody, Seth, his landlord at the new place at the end of this lease gives him notice, says, we're not going to renew your lease, but he's still there after the end of the lease. He's now a tenant at what?
Sufferance.
At sufferance. Even though he started as a periodic tenant because he had to give him notice, now we've gone past that point where he's not following the terms of the lease. He's been asked to leave. He's now a tenant at sufferance.
I think my ladies will get this. It's like an ombre. You start with a light and then you go dark.
Why do I keep hearing that word all the time now? Like it's always on the Food Network, like I'm an ombre a cake. And I was like 40 years old before I ever heard it once. Now I hear it all the time. So it's like,
I mean, that's the way I think about it. Like it like fades into something else.
The buzzword. Cherie, do you have a question?
Not so much a question, a statement. So I assume whenever you see a listing, when you see that listing that says do not disturb the current tenant, and once you purchase the property, you're responsible for removing that tenant, that might be an estate at sufferance type situation.
Could be. It could be. Could be. I mean, there might be a reason they're not cooperating with those showings. Yeah, for sure. Fleas come with the dog in that case, for sure.
You can't view the house or anything.
Yeah.
I saw a few of those this summer.
Yeah. So look at this question right here. It says, Betty's rented a property in Raleigh through Airbnb for the first weekend of the North Carolina State Fair. The rental contract is not specific on any other items other than a length of 1 weekend. This is an example of, so what do y'all think this is? Do y'all think this is a periodic tenancy? Do you think this is an estate for years? Do you think it's an estate at will, or is this an estate at sufferance?
Make sure you read the entire thing. Good job. I hope. Good thing it's not B.
I like B a lot. This is an escape for years. And so
B is the best answer.
So here's what I'm looking at here. There's two things about a lease you always pay attention to. Does it specify a time period? And does it require notice, right? Does this specify a time period?
Yes.
Yes.
Yes. Okay. So can we take away a state at will and a state at sufferance since it specifies a time period?
Yes.
Yes.
Right. Does this require notice?
No.
No. So then we can take away periodic. What are we left with?
Years.
Stay for years.
Stay for years.
Yes.
I like this 2 criteria thing that you're doing. Is this I don't think you've ever done it like straightforward like that, and I think it helps.
Yeah, I just thought of it today.
Yeah, I'll put that in your guys' recap for all of these. If you remember which has a time requirement and which does and does not have notice, I think that would really help.
Which, by the way, Seth, is very helpful. So thank you for doing that.
Oh, you're very welcome. I'm glad you guys like it.
It's like study notes.
Exactly.
Yes.
And folks, that takes us through all of the relationships. That's it. You ready for the final exam? Y'all want to get started right now?
Oh, wow.
Negative.
They should give it to us like quarterly final exam for you. And then
Yeah, you have 4
first
minutes.
quarter,
Yes.
test for the state and national.
That's what I'm gonna do. That's what I'm gonna do.
Okay, good.
Actually, I decided the other day that I'm gonna
Remember, this is being recorded.
I know. I decided the other day I was gonna give you all, because I like you as a group, I'm gonna give you the test with all the answers on it. I made that decision on Wednesday. I'm gonna give you the one.
Thank you. We'll
You're
hold
the
you to it.
best, Travis. You're the best.
I am.
That is awesome.
I'm gonna give you the one that's got all the answers. Katie said it cut out. What did I say?
Well, do we have to choose the answers?
Well, that's all you got to do. It will. I'll give you.
Well, you didn't say all that.
I'll give you all the answers. Plus, I'll give you like 3 bonus answers on each question, and you just have to pick the one you like the best. But see, I'm giving you all the answers.
That doesn't sound like an upgrade.
I give you the answer.
You had me for a minute.
Plus, I give you 3 bonus answers, and you just gotta choose which one you like the best.
I will say I'm thankful that it was multiple choice. If it was short answer, holy cow. No, the anxiety. Do I need to capitalize something?